the Planning and Environmental Appeals Directorate. I've been appointed to undertake this inquiry and to report to Scottish ministers on the application. It's been submitted, as folk will know, under Section 36 of the Electricity Act. In Section 36 cases, it's ministers that ultimately make the final decision as to whether consent should be issued, and they do that after considering my report. I can confirm that I'm going to take a full note of today's meeting. So if there are any issues with that connectivity and you miss something, you should be able to follow the discussion in the note, and we can follow up any points as necessary in correspondence. This meeting concerns the arrangement for the inquiry and the associated procedures necessary to consider the case. It doesn't form part of the inquiry itself. Therefore, no evidence on the merits of the proposal are going to be subject to discussion today. The agenda was circulated a couple of weeks ago, so parties will have had opportunity to consider my current thinking on the proposal and how we should be proceeding with the different issues. Hopefully, we'll be able to progress quickly through the various points, pausing only to debate if there's disagreement. That said, parties hopefully will have received a copy of correspondence submitted by the applicant last week, which may have a bearing on how today's meeting unfolds. Given the potential implications of the applicant's request, I'll be bringing item 11 forward in the agenda, the any other business section, just so that we can hear from the applicant on this matter specifically, and so that I can ask a few questions around the subject. I'll do this immediately after introductions, but before item 3 on the agenda. We'll then be able to discuss any additional other business, I should say, at the end of the meeting, as was originally planned. The meeting is being recorded and broadcast live. A member of our IT team will be online in case there are any technical issues. In due course, the recording will be available to view on the internet. In accepting the invitation to the meeting, you've agreed to being recorded. I will just offer this opportunity for people who are not comfortable with that to either withdraw from the meeting or to just turn off their camera if that would make them more comfortable. You might find it useful to use the grid view on this platform. As I mentioned earlier, please mute your microphone when you're not speaking. I'm going to keep an eye on participants throughout. I've got the grid view on. So if you'd like to contribute something, please do wave. There is a raise hand function at the top of the control bar. If people can see that, that's an alternative to frantically waving your hand at me. So if you press that, I'll know that you want to come in, and I'll let you in to speak at the next opportunity. Finally, even though it's a virtual meeting, it's still important to make sure that those mobile phones are turned off or switched to silent for the duration. I've not planned a formal break during today's meeting, but I'll review this after about an hour if we haven't concluded at that point, just to see whether or not people would feel that a short break would be welcome. I might also call a brief recess if I feel that I need to retire at any point during the meeting to consider something in detail before progressing further. I'm sure you'll appreciate that. Does all of that make sense at this point? Just a nod will be fine. Thank you. Okay, so we'll move on to introductions, which is part 2. I'm going to now introduce... Oh, sorry, I'm getting a slight echo. I think it's from is that yourself, Mr. Trent? Yeah, I think the echo was coming through you. Well, if it continues, we'll see what we can do. So I'm going to invite parties to introduce themselves, and where appropriate, the members of their team. And I will start with the applicant. So for Muirhall Energy Limited, if you could introduce yourselves, that'd be ideal.
Thank you, sir. Good afternoon. My name is Marcus Trinick. I'm a solicitor of King's Counsel, instructed by Neil Collar of Brodie's. And Neil Collar is in the room with me and various others who I will introduce anyway. There's Amanda Swan, who's Head of Development for the applicant, Tamika Dawson, Senior Consenting Manager, Susan Bell, Senior Development Manager, and Amy Hanley, a solicitor at Brodie's. I think watching from the sidelines is David Bell, a planner, who would be the planning witness at the inquiry. Thank you very much, sir.
Thank you very much. What I'll do is I'll take a note of all that at the end, and we'll include it when we circulate the meeting of the attendees. I can get that from the recording. We'll next go to the council, please. Scottish Borders Council.
Thank you, sir. My name is Ron Kirk. I'm a solicitor at Scottish Borders Council. I'm not actually the principal solicitor involved in this matter. I'm covering this meeting for my colleague Sarah Thompson, who unfortunately is not available today. She's covering the council's planning committee meeting, so I'm covering it in her place.
Okay, thank you very much. We do have 3 community councils that have opted into the process and have indicated a desire to participate. If those are here, I'll ask them to introduce themselves in the order set out in the agenda, if that avoids people talking over each other.
Yeah, I'm Walter Douglas. I'm the current chair of the Teviot and Borthwick Water Community Council. I do appear else further down the list as a private individual, but I'll just be representing the Community Council today. Thank you.
Okay, thank you very much. Okay, thank you, thank you very much, Mr. Cobb. There was some distortion there as you were speaking. If there are any issues later on when we come to your contribution, we'll try to find a workaround on that. We do hopefully have a chat function as well. So if it's not possible to understand as you're speaking, we'll be able to take some questions or comments through that. There's a button at the top there that you'll be able to input any specifics if we can't hear you. And South Dean?
Yeah, for the chair of South Dean Community Council, and that's the party I'm representing today.
That's great, thank you very much. We also have the Defence Infrastructure Organisation. There's an opted-in party.
James Ruth Crawford. I'm a member of the Faculty of Advocates in the King's Council. I'm instructed on behalf of Morton Fraser McRoberts. My principal instructing agent is Douglas Milne, who is with me this afternoon, along with his assistant, Mr. Douglas Harvey. And online, we also have Mr. Des Egan and Mr. James Houghton from the MOD, which is a broad descriptor for their various interests.
That's great, thank you very much for that. And we have NAT Safeguarding, National Air Traffic Control.
Afternoon, Alistair Rolfe here representing NAT Safeguarding.
Thank you. Apologies for my back in the dark ages with my pen and paper. And then Dr. Ford, I believe you're representing the Landscape Conservation Group.
Yes, good afternoon, sir. I'm Dr. Christopher Ford on behalf of Teviot Landscape Conservation Group. That's quite right. Thank you.
Thank you very much. I was waiting for somebody else to pronounce the name of the village there, so that I didn't make the mistake of mispronouncing things. I've learned valuable lessons in the past. So we'll now work through the list of the other interested parties to check everybody is present and to establish whether they're acting on a private basis or if they're representing a particular body or organisation. I have had 1 or 2 apologies from people that do want to participate, but unfortunately due to work commitments they couldn't be involved today. So they'll be proceeding with the inquiry as we go forward. I'll be copying them into the note of the meeting and finding out from them which matters they wish to give evidence on. So I'll just go down through the list as I have it, and just to give me a hello and just to notify me if you're acting for anybody else. So we have Caroline Gray.
Yeah, that's me. I'm just private individual.
That's great, thank you. Elizabeth Little.
Yeah, that's me. And I'm a private individual as well.
Thank you. Helen Chatterton. I'll check my apologies. It may be that that we've had apologies on the behalf. Jane Bauer.
Hello, I'm a hill farmer in the Hermitage Valley here in a private capacity.
Thank you. Mr. Dawson.
Hello there. I'm also a private individual, Rosamund Hoyk.
Thank you. Pat Douglas.
Yeah, that's me. I'm a private individual but resident in the Teviot Valley.
Thank you very much. Marion Livingston. Today, okay. Mark Chatterton. Okay. Mr. Looking, Stephen Looking. No. Mr. Moffat.
Hello, I'm Kenneth Moffat. I'm a resident of Teviot Head, a business owner, and I represent the Borderlands Museum based at Teviot Head.
Okie dokie, thank you. Thank you. Walter Douglas. Oh, we've already spoken to you. Thank you. Patricia Douglas.
I'm Pat Douglas and Patricia Douglas.
Oh, sorry. Okay, no problem.
Actually, also secretary of the Teviot Landscape Conservation Group, so I think that's why I'm on twice. But today I'm here on a personal basis.
Okie dokie, thank you very much. Mr. Pow, James Pow. I've definitely had apologies from Gillian Cooper this morning. John Turner. Tamsin Turner, I'm assuming is no as well. And then we have Claire Novica Price.
Yeah, Claire Novica Price. I'm here as a private individual representing my business as well.
Okay, thank you. I'm sorry for the pronunciation there. I'll aim to get it right next time. Okay, so thank you very much for that. Are there any preliminary questions or issues to raise at this stage before we get underway? Mr. Moffat.
I might ask your position. Will you be coming down to visit yourself?
Yeah.
Yes, and then you'll report, and you're an independent agency.
Well, I work. Yeah, we're an independent directorate of the government that deals with planning and environmental appeals primarily. But for Section 36 applications where a public inquiry has been triggered, in this case by the local authority objecting to the proposal, it comes to myself to organise a public inquiry. So we'll talk through it a little more through the agenda, but what that generally entails is I look at the different outstanding issues. I identify those issues where I think that I'd benefit from further information, and then I determine which procedures to go through. So that might be further submissions, a hearing session, or an inquiry session. Or I might consider that certain areas I've got enough information to make to provide advice to ministers on that matter. I will come down to undertake site inspections unaccompanied, potentially accompanied. I'll go over the situations where that will occur later. And then the oral sessions will be in person at a local venue. We'll take evidence at those, and then following that and following the closing submissions, I'll make my recommendations in a report that will be submitted to ministers' consideration.
Okay, thank you for that, because I'm not familiar with the process altogether. Yeah. But I did notice that there's an absence of a community hearing on your agenda, which I was quite concerned with, and I'm sure everybody else will be, because I think it's a really aspect.
It is there. There is in my notes for today. We will be asking about interest for that, and if there is any desire expressed, we'll certainly be looking at arranging a separate community session for local residents and interests, and I'd recommend that takes place in the evening to maximise attendance from people, so that they can come out with working hours. So don't worry about that. We'll certainly be offering that opportunity.
Thank you.
No problem. Anything else before we move forward? No. Okay, thank you. So I'm just going to briefly go to what I'm deeming on my notes here as item 11A, which is going to be about Eskdale Muir. Sorry again if I've mispronounced that. But as I've said in my introduction, before we go any further through the agenda, I'd like to consider the correspondence that was submitted by the applicant last week regarding this this matter. As parties will see from my circulated agenda, I had already identified the potential effects of the proposed development on the array as being a matter which I felt required further procedure. So my original intention was to request further written submissions to clarify the scope of the issue and to set out agreed mitigation between the applicant and the MOD. Had that not been possible, if it hadn't been possible for the applicant to negotiate a solution on this matter, for example, through the wording of a planning condition, within a prescribed period, then I had intended for the matter to be considered during a hearing session. So just now, in the first instance, I'm going to invite the applicant to talk through the content of last week's letter and the anticipated timetable for the issue of the emerging regulations. And then I'll maybe come back to the MOD for their views on the matter. Subsequent to this, I'll probably have some more questions. I have got a couple noted, and there may be additional ones, in particular surrounding the technical issues as referred to on the second page of the submission, and the potential implications of those on the overall scheme design. But as I said, in the first instance, I'd like, if you could, please talk me through the situation, Mr. Trinnett, and the outline the applicant's suggested approach to dealing with this issue through the inquiry process. Thank you.
Thank you, sir. Yes, I hope that people have had a chance to glance through the letter that was sent out by Brody's last week. I won't read it through verbatim, but broadly summarize as follows. The purpose of the letter is to seek a continuation of the application so that the inquiry would not start until, I put at least August. I'll come back to what I mean by at least August 2026. And the reason for that is that extremely substantial progress has been made and is being made towards a resolution of the Eskdale Muir issue. That has been said before at inquiry. It was said at Greystone now in March. Since then, a lot has crystallised into a series of timed steps as follows. That later this month, we hope, the MOD will publish its new safeguarding approach to the Eskdale Muir seismic array. The MOD consulted upon that in October 2024, is now wishing to finalise the approach. At the same time, the MOD has been doing an awful lot of work to calculate the seismic headroom available to new development under the ceiling, which is expressed in nanometers per second. When the seismic headroom, which takes account of that which has been used by operational and consented developments to date, by what is left to be used. Thirdly, in January 26th, Department for Energy of the UK government and the Scottish government will consult on technical guidance, which proposes steps to, lovely word, optimise, maximise, whatever you want, development within the 50-kilometre zone around the array, within which consultation with the MOD on applications for consents is now required and will be required. That consultation period will be about 6 weeks and takes account of the fact that there are, of course, certain elections taking place in May. The other factor here is the UK Infrastructure and Planning Bill, which is expected to receive royal assent this month. That bill contains provisions enabling regulations to be made to secure the safeguarding of the array and to optimise development within the 50-kilometre zone. Those provisions will come into force 2 months after royal assent. At the same time, and in pursuance of the bill, or it'll be act fairly soon, that regulations are being drafted to further protect the SDL Muir array. They're being worked on now within the UK government, and they should be ready for deposit in the UK Parliament in May 26, my apologies, at which time the UK and Scottish governments will reply to the consultation responses received within the 6-week period I referred to. It's intended those regulations will become law later in 2026, date unknown at the moment. But in the meantime, and probably within May 26, it's proposed there will be a written ministerial statement which will, if it's supported by the MOD, enable the release of headroom for developments such as Teviot. Now, if what is set out in the previous paragraphs goes ahead, paragraphs of the letter, the MOD will be able to respond positively to applications such as that for Teviot, provided the project does not exceed what will be termed a seismic impact limit. That seismic impact limit will be the same for all developments within 50 kilometres of the array, and provided also the development is not within a defined distance from the array, it's likely that that distance will be increased from the current advisory 10 kilometres to a statutory 15 kilometres, but that's in the future and the matter for consultation, so that's guesswork at this stage. But that exclusion zone will almost certainly not affect Teviot, that's the point. Whether or not Teviot would meet a seismic impact limit depends on a whole series of turbine selections and detailed technical issues. I'll return to those issues shortly. What the applicant does not want is to be forced to go to inquiry in advance of these steps being taken. The inquiry will take place because Scottish Borders Council has objected, but it'll be far better timed when a lot more is known about the way forward on SDL Muir. The MOD does have a limited resource to deal with SDL Muir related matters, and its time, frankly, sir, is going to be far better spent at the moment taking forward general issues relating to SDL Muir than in inquiries. Indeed, we know, and I think that Ruth Crawford will support this, that if the MOD had to divert resource to the Teviot inquiry or any other inquiry in the short term, then it would take away from the resource which it's much better, would be much better used in reaching an overall solution. For these reasons, premature in our view to go to inquiry in March or indeed June, and preferable to wait until roughly August. I add to my letter these points that, firstly, I don't expect you, sir, to go nap on a date for the inquiry now or having thought about it. My suggestion would be that we have a second pre-examination meeting. I would suggest sometime like mid-February, early March, when we will know a lot more about whether the steps which I've outlined are being taken, have been taken, will be taken. Pretty sure they will be, but you don't know that, and you need reassurance on that. Secondly, I know the MOD cannot commit at the moment to the certainty of a positive outcome of the whole SDL Muir process, but I'm sure that they would agree on these points that great progress has been made in 2025, probably since March 25, towards these now timed steps. Secondly, that the dates I've set out in the letter are, so far as we know, always subject to politics, but are correct. And thirdly, that the MOD, the Scottish Government and the Department of Energy of the UK Government are all pressing hard for a positive outcome at the moment. All the matters I've set out in this letter are in the public domain, although I have to say they've been communicated so far to the industry by the Department of Energy and by the Scottish Government. but they are in the public domain and can be verified and can be confirmed by the MOD in a moment. I return finally to the question of technical evidence. If we went now to inquiry in March or indeed in June, it is inevitable, and I fully understand the MOD's position on this, that they will feel obliged to bring extensive technical evidence. That would take a long time, it would take a lot of resource, it would take a lot of public expense. That resource, time and expense can be avoided if we look ahead further to the start date of the inquiry. My guess is August 26th, but we will know more in late February or early March. Thank you, sir. I'm ready to take any questions.
Thank you. Before I come back to questions on that from myself, I would like to ask Ms. Crawford whether or not what you've just heard and the contents of that letter there align with your client's understanding of the situation, whether there's anything else that you'd like to add at this point before I go on to my questions.
Yes, thank you, sir, and I'm grateful for the opportunity to respond. The steps outlined in the letter from Brodie's are not in any way taken issue with. However, as may be obvious from those steps, while the MOD will do all that it can to achieve those timescales, and as alluded to briefly by Mr. Trinick, matters can slip. And I think we just have to recognise that, even with all good intent and everybody using their best endeavours. However, the timetable is set out, or the proposed steps are set out in the Brodie's letter, are correct, and I'm quite content for that to be placed on the record. I should also indicate, and as again Mr. Trinick has alluded to, the landscape, no pun intended, in relation to assessment of the impact of wind farms on the array has changed seismically. Again, no pun intended. Previously, or as currently advised, the industry and indeed the MOD works to a threshold calculated by use of an algorithm which was developed many years ago now. You will see, sir, that it's proposed to move to something called a seismic impact limit, as and when the technical evidence is available and has been properly verified. That is a complete change, sea change in how the MOD has previously looked at wind farm development in the area. And the reason I make that point is, again, to add my support or acceptance of Mr. Trinick's position, whereby if we were to proceed to inquiry prior to the work as set out in the Brodie's letter being carried out, the MOD would maintain its current position based on the existing accepted science and the technical evidence which underlies all that, and maintain its objection to the development on that basis. You suggested, sir, that a hearing session may be appropriate to hear that technical evidence. My experience suggests that it might be better addressed, depending on the extent to which the existing technical evidence is disputed. It might be better to address that at inquiry. All that is just to say that in the real world, if we were to proceed to inquiry before this work was undergone, much of that evidence may, while of interest by way of background, may be rendered redundant and academic should the anticipated steps in fact come to something. So it may, in the real world, not be entirely sensible or a good use of all parties' resources, including the MOD's resources, to proceed to prepare for an inquiry based on old science, which has been overtaken by new science. It's that new science not yet having been vouched and verified and assessed by the MOD. All that said, sir, the MOD does not, and again, this may be appreciated by Mr. Trinick and the applicant, the MOD does not adopt either a positive or negative viewpoint in relation to the request for a continuation. It adopts a neutral position against that actual background.
Okay, thank you very much. So I suppose the first, just for my own, just for my note here, the first thing to ask of you then, Mr. Trinick, is confirmation of the distance of the application site from the array, just for my note. You were talking about the exclusion zone, you see, so I'm just trying to get these facts in my mind.
It's greater than 15 kilometres.
We know it's more than 15 kilometres and under 20 kilometres. It's between 15 and 20.
That's nearest.
I can give you the exact figures after the meeting, sir.
That'd be great, thank you. Okay, so I appreciate at this time it's not possible to be certain regarding the implications for the emerging regulations for the proposed scheme. And I will ask, though, maybe for a little speculation on the part of the applicant here, and maybe not appropriate to ask of the MOD, but if it's anticipated that there's a reasonable chance that the scheme design, in particular the placement of the turbines, might need to be amended in response to these regulations, or is it more likely that device typology and the construction detailing would be sufficient to achieve compliance with the seismic impact limit?
That's a very good question, sir, to which the answer is not currently anticipated. Is not currently anticipated. We will need to make scheme amendments.
Okay.
But the reason I say not currently anticipated feeds into what Ruth Crawford said, that until we know the results of the MOD baseline audit, we do not know, and I'll be fair to the MD, we do not know if or how much headroom will be available. We do not know, therefore know what the seismic impact limit value will be, and that value coupled with the minimum target that UK government will set a development within the 50-kilometre zone will govern the way in which Teviot will be able to proceed. It's a very high-level answer, so I can't do better for the moment.
Yeah, I suppose what I'm trying to get to for myself is that if it's a seismic constraint that's based upon obviously the vibration, it's not based upon a visual effect or anything like that, or a specific obstruction. So what I was wondering whether you consider that vibration can be reduced with the current proposed layout, because as you'll know, I wouldn't like to pause things if we can make progress on the other issues, providing that progress isn't abortive. What I'd like to be comfortable with is that, I mean, for myself, what I can envisage is if in an ideal world we could progress on the other matters, whether or not there's the additional environmental information accepted that has been suggested within the position statement. If we could progress on that and even go through the inquiry process on the understanding that maybe even subsequent to those oral sessions, we have a round of further written submissions or even an inquiry session, if necessary, on this specific topic area. What level of confidence would you have that work wouldn't be abortive? I don't want to do that and then us to come around and say, well, actually, we need to move everything X meters away, and then it suddenly makes our other work a waste of everybody's time. Mr. Trinick.
So I can't give you a guarantee that no scheme changes would be required. I can't say that.
No.
It is possible that some turbines might have to be moved. I can't guarantee. It's not currently anticipated that would be the case, but I would be foolish to sit here and say it won't be necessary.
Yeah.
Secondly, and I think another argument perhaps against going ahead with other issues at the moment is that, well, firstly, of course, obviously, that the visual situation might change if it were necessary to change some turbines, but equally, there can be changes in other circumstances over time, which might mean you might need to revisit the issues covered. It would seem to me preferable to cover all the issues at one time.
So in that case, if there's the potential for this scheme redesign that could prove abortive, that could also prove abortive for the additional environmental information that has been requested in terms of the reduction of 5 turbines and the production of the additional information that has been suggested should be submitted.
Not quite so. No, we haven't come on to the item on the agenda yet, but in fact, the need for additional information for purposes other than Estill Muir has been reduced very considerably, and in fact down to one issue, which is an update on some Eagle data, which I think may or may not be additional information which requires investment. I'm not sure about that yet. It probably does, but there is no present proposal to remove any turbines. That issue has gone away, and I apologise for the hair which was set running in the position statement, but those matters have now been resolved. The scheme is as it will be, subject to Estill Muir.
Okay. I would like to just, whilst I'm appreciative that this matter isn't a matter that the other parties that are involved in this meeting have raised objections to, and obviously any potential delay is going to be unsettling or cause frustration for other people at this stage. But if there are any comments that other parties would like to make at this point, I'd be interested to just take those on board. I'll start with Mr. Moffat there.
I was just interested what everybody's discussing about wasting everybody's time and resources effectively, because as far as I understand, the Estill Muir seismic is subject to international agreements from seismic stations around the world. And the second point, which doesn't seem to be addressed but must have been addressed surely, is that this is a low-flying training area, an electronic warfare training area, and Spidadum, just over the border, is the only live firing site for training we have in the UK. These turbines will surely impact effectively upon the security of the country if we don't have the facilities for low-flying exercises.
Yeah, just to reassure you there, we do have civil and defence aviation as a matter separate from this, that is in its own right subject to further written submissions, which I'm going to need clarification on before I can make my recommendations. So I appreciate that. I appreciate that there are many issues to be taken into consideration. There's a lot of cogs. The same with any wind farm. In terms of the international approval, the timetable that's been set out and the regulations that are going to be approved, I'm confident that that timetable will include the necessary steps that need to be taken to resolve that as an issue. That's not really something that I myself would be involved in. If the updated legislation or guidance regulations is passed, that's what we'll be working to, and from our position, that should meet all national and international obligations. Thank you. Dr. Ford?
Thank you, sir. Can I just raise some general concerns about the process? This is an application which was lodged in May 2022. If you look at the time that the application took up until the point where the council decided its position on the case, a fair amount of that was actually attributable to the applicant, effectively going slowly in terms of responding to the information requests and the dialogue with the council about the details of the case. It's fairly obvious also, since the case was objected to by the Borders Council, that the applicant is taking a similar process for the last few months as well, in terms of treading water, essentially. In general terms, within the planning system, certainly planners, we know that major developments have quite an impact on the local affected communities. We kind of understand that for the period where a proposal is up for consideration, that's a burden that communities carry. It has some direct effects on the communities. It affects things like property value, for example. And whilst property value is not a material consideration within the the merits of the case, it's obviously not a material consideration. It's certainly a relevant consideration in terms of how it affects the community whilst these proposals are being considered. It's not unusual for property values to be deeply depressed during this period. You also get some situations where people can't actually sell their homes where they would normally want to move on in that period, basically under perfectly normal conditions, accepting the proposal. And it also creates considerable stress within the community because there's all sorts of tensions for and against proposals and all sorts of issues around it. Okay, so generally speaking, it is a burden that we put on within the planning system. We put on communities whilst major applications are being considered. However, this application has been around for well over 3 years now, 3.5 years. We're now talking about, normally this case will be resolved by the end of 2026 at the latest. It now looks like it's going into 2027. That's a huge burden to be putting on a community. And whilst it's a relatively small community, there are several hundred homes within 2 or 3 kilometres of the site and therefore all affected. And if you go up to 10 kilometres, the number increases, obviously. And that's beyond the normal kind of effect of amenity assessment, from visual impact and so on. So I think we should be taking account here of the impact on the community and the way, in a sense, we should be moving towards a decision on this case as reasonably soon as possible. If you look at the substance of what Mr. Trinick has said in his submission, essentially there's all sorts of ifs and buts and maybes and doubts and uncertainties and absolutely nothing is clear. I appreciate Ms. Crawford has given the general picture on this kind of stuff in terms of confirming the sense of direction. But there is a huge amount of doubt and uncertainty beyond that, which may well intervene. And I think it's quite likely that if this is delayed, for example, till August, that we might be back in here, sometime in the summertime asking for another extension. If you look at the issues that are involved in this, they're actually very substantial. There's issues, for example, about the fact that the UK government is taking over responsibility for this, whereas in the past it's been dealt with by the Scottish government. And there's all sorts of issues around how this actually falls out in practice. This is by no means a certain process. There are all sorts of uncertainties. I think it's generally known about the 15 kilometres, not a huge surprise. But the area of doubt is actually what will happen to the way in which the formula is put into practice. And I can see this has been an area where there's already been litigation on the subject. It's quite likely there's likely to be more litigation in the future. That could take another 6 to 9 to 12 months. So realistically, this issue, is going to cause considerable uncertainty. And what I'm trying to say is that there is no clarity at all, no certainty that this matter will be resolved during the decision period that you would normally be given to yourself, sir. You would normally be given 50 weeks. That would take you to midsummer 2026. And from what's being said here, this looks like it could run for another year or so beyond that, realistically.
Yeah, I fully appreciate what you're saying.
Can I just complete the point, sir? Because I'd like to move on to the formal points here as well. Effectively, the applicant is asking for a SIST. And as you're well aware, sir, SISTs are not allowed under the DPA rules. The other thing about this is effectively it's talking about a change in policy. The normal way we would treat a change in policy within a decision process is that we give it little to no weight. And given the uncertainty here, effectively we should be giving this no weight at all. Another point to be made is that the code of practice relies full disclosure and early disclosure. Mr. Trinick admitted to, and I'm also aware of the fact that a lot of this stuff is in the public domain and has been in the public domain for a couple of months or more. And therefore, the idea that we've had less than 1 business day's notice of this is a grave concern to my clients. And whilst I accept there's a practicality about how this issue will be faced at some point with this application, I do think you have to have regard to the general process that's going on here. If the applicant wishes to take control over the timing of this consideration, The answer is they should withdraw their application and lodge it again and restart the process. So generally, sir, I'm flagging up that the community are severely affected by this uncertainty. And I would respectfully suggest that the real solution here is to move forward with the proposal. In the event that things change during the normal schedule, we can take account of that. Things may not become clear until after your report is submitted in July next year. And in which case it'll be down to the Scottish Government to deal with it. And it may be that this issue is actually not clear for even into 2027, looking at the complexities of the issues here. So I would ask you, sir, it is obviously, and I fully respect your decision, sir, it is a matter for you, but put it this way, sir, the community is gravely concerned about the process that's been going on here. Thank you.
Thank you very much. I do sympathise with your position. I'm sure that everybody and everybody involved wants to see things resolved. And I am aware of our timetables that we aspire to meet. Of course, those aren't statutory timetables. That is our targets, and sometimes things do occur and matters do come up that unfortunately delay matters. And from it coming to us, I understand that there's been it's taken a long time to get to where it is now. For myself, seeing that the timetable that's been set out there, and I totally agree that there's the potential for slippage, and that's been acknowledged from the parties involved. But from looking at the notification there saying that in January there'll be a consultation on technical guidance, if that was to take place in January, I mean, that's a significant material. I need to take that into account in my assessment of this proposal and in my drafting of my recommendations. Talking about the submission of a bill at the timetable that's suggested here, and the deposition of regulations in May. Even if we went to our swiftest possible, I can see that, yeah, I will come back to you. Even if we went on the swiftest possible timetable here, as I've planned various timetables here based upon if we just go straight ahead now, if we accept additional environmental information, or if we potentially take this into account. And even if we take the fastest approach, it's unlikely that my report is going to be submitted before this is submitted to Parliament, which could potentially mean that there are substantial changes, not just what the scheme has to deliver on site, but to the legislative framework which we're working to. I will just go, before I come back to yourself, I will go to the applicant there to see if there's anything that they'd like to respond to in particular before we progress onward. Mr. Trinick.
So the applicant has the same sympathy as you for people who are in limbo, waiting, concerned for the outcome of this application. Mr. Ford may shake his head. He's wrong. We do have concern for that.
Okay. We'll treat each other with respect here, the way that we want to be.
Thank you.
You know, I can understand that people's frustrated with the situation, and we're going to do everything that we can. I'm going to do everything I can to progress this appropriately and to take a balanced approach to assessing the considerations that are before me. And I hope that I've set that out in my agenda for this meeting so that you can see my initial thinking on this. We are, as I was asked earlier, by Mr. Moffat, we are an impartial body that is going to assess this. So if you all treat each other with respect, and myself, we'll get through this, and we'll get through it as swiftly as possible. I don't want delays either that are avoidable. Mr. Trinick.
Thanks, sir. Yeah, as I said, the applicant does have sympathy for all those involved in the application. These applications anyway take a lot of time. The applicant has not been going slow. They've been progressing additional information at various stages. which was actually published in June 24, we did not get a consultation response back until March 25. So these things do take time. In terms of just progressing now, as you have said, by the time you submit your report, things will have happened about Esdalemuir, and there is at least the potential, and I don't know for what, but there is the potential that we would have to come back to inquiry after the submission of your report, which would be highly unsatisfactory, by which time other circumstances might have changed, which, as I said earlier, might involve reopening issues already debated in the earlier sessions. So I don't think it would be a good use of time to simply proceed to inquiry now. Far better to take the option which we've offered. But sir, have I answered the points that you wanted me to answer?
You have, yes. Before I go back to Dr. Ford or to Mr. Douglas there, I do, obviously, if there were to be an extension, it couldn't be an open door and an endless path. So we've already been told that there are some uncertainties regarding the timetable. If there is an abeyance, if you like, and we come back with another pre-examination meeting, what you suggested earlier, dates there in March, mid-February, early March, did you say? What position would we be in at that point that's different to now? What certainty would we have at that point that we could progress that we don't have at the moment?
Well, so the Ms. Crawford will have to confirm for the MOD, but the clear understanding is that the MOD will by then have published its safeguarding approach to applications. Secondly, it will have published its audit of the baseline. Thirdly, the DESNES, the Department of Energy of the UK government and the Scottish government will have consulted on the technical guidance. We will be in the consultation period, I agree. We might set the pre-examination meeting for a bit later, but at that stage also we will know that the Planning Infrastructure Bill has become law. We will know therefore that the provisions for Esdalemuir, very explicitly inserted in the House of Lords at the third reading stage, will be law. Well, they come into effect 2 months after the Royal Assent. We will know more about the regulations which have been drafted. So I would say by early March, we will have all that information, and you will have a lot more certainty about whether the steps outlined in the letter are being taken or will be taken. So that's my suggestion for a date for a second pre-examination meeting.
Okay, thank you. I'm going to go to Mr. Douglas, and then I'm going to come back to yourself, Mr. Ford, Dr. Ford, because and to Ms. Crawford as well. I'll go to Ms. Crawford first, actually, Mr. Douglas. Apologies for that. This might just offer a little more clarity on the matter that we're discussing. Ms. Crawford.
Thank you, sir. Apologies to those who've been waiting patiently with their hands up. For what it's worth, if you are minded to postpone the inquiry until August at the latest, the MOD would agree that it would be sensible to have a further pre-inquiry meeting. The exact timing of that can no doubt be discussed, but this is why I also put my hand up in the context of the timing for that. As everybody can see, there's a lot of work to be done in the next few months. As the letter from the applicant sets out in the second page, it's hoped that the MOD will be able to respond positively to applications such as this, provided it does not exceed what is called the seismic impact limit, and provided the application is not within a defined distance from the array. 2 points arise there. First of all, you asked, sir, about the distance of the application from the array. My understanding is that the turbines variously are between 16 and 21 kilometres from the array. That leads on to the next point relative to the sill. And just so there's no doubt in the applicant's mind in relation to the MOD's likely position, which is to the effect that with that level of distance, the MOD's provisional view at this stage is that it likely needs some form of engineering mitigation to bring the project within the sill. And if that's the case, the MOD is unlikely to agree to a suspensive condition if we're bringing in forms of engineering mitigation. And in that event, the MOD is likely to object unless the number of turbines are removed. The point I make here, and again, we're in the realm of uncertain, we don't know, it depends. But it's just to say that, albeit the work will be done, it may be that further consideration has to be given to mitigation and the like, which may yet require to be addressed at a hearing and/or inquiry session, even with all this work which has been done in the principles as to how the impact on the array is worked out. I don't wish to set any hairs running here, but I just wish the MOD's position to be open and transparent for all concerned.
Okay, thank you very much. Mr. Douglas.
Thank you, sir. Just a point on from the community's point of view, the letter we received from Brodie's on Friday. I find the last sentence quite concerning. The continuation sought would, of course, enable the applicant and Scottish Borders Council to attempt to further narrow differences on other issues. And I just wonder, where does the community fit into all this? Where do the community and other people fit into this? It sounds as if there's going to be some cosy behind doors negotiation going on to try and, and we're going to play no part in that. So that's a worrying concern for us as a community, I think. Thank you.
Thank you, Mr. Douglas. I think, I can see where the choice of words may set you on edge a little. I think the council's objections is what there'll be perhaps potential for negotiation on between the applicant and the council, which is fairly normal in terms of what the specific objections were from the council. There are obviously other issues before us beyond those, and regardless of whether or not those matters are things may appear to the council that they don't object on certain grounds, that upon examination by a reporter, occasionally it's the case that they find differently. So I think that agreement in this instance could include things like planning conditions or conditions for the consent, just to speed up the process later on, because you'll have seen that in the agenda that there's a suggested conditions hearing. What normally takes place during the whole of the inquiry process is that should ministers choose to grant consent, that would be subject to conditions, and those conditions are traditionally agreed between the applicant and the council as far as possible before I submit my report, and then I make my recommendations where there are instances of disagreement. So I would imagine that it'd be on those sorts of matters that there'd be additional engagement. I don't know if you would like to offer any reassurances on that basis, Mr. Trinick.
Yes, so the choice of words at the end of the letter might have been better put. I agree with that. Of course, there's no cosy deal. Anything that we put to Scottish Borders Council would be consulted upon, and the community would be brought into that consultation. So apologies for any infelicitous words. And just coming back on one point, sir, answering what Ruth Crawford said. Will we need mitigation? Well, maybe not. We don't know. We simply don't know at this stage. No one can tell. But what is certain is that if we go to public inquiry now and debate the technical issues on the basis of old science, and then the MOD is not happy on the basis of new science at a later stage, we'll have to come back all over again and debate the issues. And that really would be an unfortunate use of time. It's far better to, if we have to go to inquiry on this issue, which we hope we won't have to in the fullness of time, go once, not twice.
Thank you. I'm going to come back to Dr. Ford briefly, and then I see there's another hand raised there, so I'll go there as well. Dr. Ford.
Thank you very much, sir. 2 or 3 brief points. First of all, The community will be looking for consistency in the way that this is being handled, particularly compared to other wind farm applications, which are currently either in process or well down the process. I'm aware, for example, that in both Greystone and at Scoop Hill, the reporters held strictly to their timetable and delivered their report within the normal schedule. Secondly, to make the point that even within the information that's been given here today, if you look at the details of this, and I have spent some time looking at the details, particularly how this might fall out in terms of planning issues, there is considerable uncertainty. Okay, not just the uncertainty about getting this new arrangement into place, but there's also considerable uncertainty around how it will operate in practice. I strongly suspect that we might, even come the summertime, and the apparent certainty that will arise at that point, still be in a period of uncertainty, and I think it'll go well beyond that, thirdly. And then the third point is that it will be evident to you, sir, that never mind whether there's been cosy deals or not, the fact of the matter is the way this looks to the community does look as though there's cosy deals going on, frankly. I have a professional obligation here to the public interest, sir, not actually to my immediate client. But it is very difficult to convince the community that there isn't a cosy deal here going on, because everything points to it. And I'm not making any judgments about whether there is or not. But the point is, it's not just about whether or not there is, but in the planning system, we take account of what things look like. And certainly in the legal system as well, we take account of what things look like as well. So I just want to raise the concern that this doesn't look very well at all for the community. You know, it just plays really badly. It's very difficult for me as a professional to actually defend my client.
Thank you very much. Mr. Kolb?
Thank you, sir. Yes, I'm very concerned, as has been expressed already, at the potential for this inquiry to be open-ended rather than to come to some timely conclusion. And you've alluded to the consultation, the technical consultation, which will take place in January or February next year. Well, consultations, once the consultation period is over, then there's a consideration, then there's a distillation of the views, and then finally the government produces a response to the consultation. Well, that normally takes about a year, and this is a technical consultation, so it's not going to take any less than that. And also the client, the applicant has alluded to the fact that there might have to be significant changes to the scheme on the back of the Eskdale-Muir noise budget management changes. And if there are significant changes to the scheme, then they will have to be consulted on with the local communities and other bodies to make sure that they meet other standards and specifications. So the potential for this inquiry to head off into the sunset in an open-ended way is quite significant. I do think that in the circumstances, the applicant would be best in abandoning this particular application so that it can consult properly and in a timely manner, and then come back with a properly set up application later on. Thank you.
Thank you very much. Mr. Kerr?
Good afternoon, sir. The issue here is clearly uncertainty, and so far we've been talking about the Eskdale-Muir uncertainty and the changes being made. But should one delay for that reason, then wouldn't the communities also have grounds for other uncertainties, namely grid connection, which is currently ongoing, and we had our first announcement from NESO today about the queue, and those sitting around the room with Mr. Trinick may be waiting for the facts to come in from NESO to say whether they've got a gate 2 or not. But also we've got the Strategic Spatial Energy Plan, which I'm sure factors into your consideration. Now, we just had an email from NESO today to say that the decision now is going to be delivered in August 2027. And similarly, the RESPs are going to be delivered in 2020 by the end of 2028. If the Eskdale-Muir delay is granted on the behalf of the applicant, shouldn't the communities also have the right to extend further? Or, and as Mr. Kilby has pointed out, couldn't this become an indefinite extension because various obstacles are being put in the way that makes the decision-making even harder to take, because it is government decisions here that are changing the basis? Wouldn't it be better to proceed with the facts as they currently stand? But there are numerous uncertainties here, which actually may mean that withdrawal is actually the right result. Thank you, sir.
Very much. So I'm conscious that we've exceeded our initial hour. What I'm going to do is suggest that we have a brief break. It would be quite timeous for myself in terms of considering what I've heard already and looking over my notes and my potential timetables before making any rash or knee-jerk decisions on my own behalf, which I do my very best to avoid. But before I do go to a break, I am just going to allow Mr. Trinick to come back on the things that have been heard, and I'll also go over to Ms. Douglas there, who I see you've got your hand up. I'll do that first, and just bear in mind that you're muted at the moment. So if you press your mic button at the top, we'll be able to hear you. Thank you.
Hi, yeah, it's Claire Novitz-Price actually, and not Pat that's speaking.
Sorry.
But listening to all this, my concerns are that the local community have spent considerable time and money already expecting to go to public inquiry in a timely fashion. And I say a lot of money, time and effort has been spent on a scheme. We were then informed that Muir Hall, quite late in the process, were going to take away some turbines. So that obviously was addressed a little bit. And obviously today we've heard that that's not the case. And late on Friday we received the correspondence saying that this is going to be kicked into the long grass is basically the only way I would put it. There are other inquiries that go ahead with the noise budget outstanding and other issues, but they still keep a timely fashion. I just feel at the moment like the applicant is looking to postpone this inquiry until they have more favourable conditions, and surely that's not fair or impartial. And I'm sitting here as somebody who's hugely affected by this, almost incredibly upset that this process seems to be going entirely south, and that we are going to be left very much adrift as a community. And I'm extremely upset about the way that it's looking to go. And I just wanted to have that set on record.
Okay, thank you very much. And as again, I have sympathy with the position, and I apologise. But I apologise as well on behalf of ourselves for not receiving the correspondence until Friday. That's when I received it as well. However, that was submitted by the applicant a few days earlier. It was submitted on the Wednesday. So whilst it's still fairly short notice, it could have been with you earlier, but our own internal processes were such that it didn't actually find its way to myself for an instruction to be circulated until Friday. So there's an apology there from myself. I'll go back to Mr. Trinick before I pause for a brief recess.
I don't think there's much else I want to say, sir.
Okay.
I've still got it, but just drawing a distinction between this application and Scoop Hill and Greystone now. In Scoop Hill, the applicant chose to do battle with the MOD on technical issues. That is not what we want to do here. We're taking a different approach. At Greystone now, there was no technical evidence. There was simply a hearing session debate about a suspensive condition. So those two cases are very different to this case. Equally, the progress which has been reported in Brodie's letter could not have been reported at the time of Scoop Hill and Greystone now. We were looking into a very uncertain future indeed, and the reporter in Greystone now declined on my request to postpone the inquiry, and I think probably rightly so, because there was no timetable on the horizon. Now the position, as set out in the Brodie's letter, is, we say, very different. Thank you, sir.
Okay, thank you very much, everybody, for your time so far. I am going to allow everybody a quick comfort break and to maybe get yourself a a drink, what I'd suggest is that we just come back in 15 minutes, so 2:25 and we'll just pause proceedings until then, and I'll see you shortly. Thank you. Everybody, welcome back. Hopefully that's everybody here. Okay, so I'll get straight into things. So thank you very much to everybody for your time so far. That item was far more complicated and in-depth than I envisaged that it would be when I was writing my initial notes there. Taking everything that I've heard into account, in particular, the progress I'm assured will be made in the coming weeks in relation to the technical guidance. And given that I've already identified the impact on the array as a matter requiring further procedure, it would appear to me, on balance, to be reasonable at this stage just to pause temporarily. However, this isn't going to be an open-ended delay by any means, and it won't in itself result in any further delays if the anticipated progress has not been made. Given that there's the potential for the need of a redesign of the scheme or the relocation of some turbines, I'm not convinced that dedicating time and resources at this stage to gain an understanding of the issues identified would be entirely sensible. Given the information that's been presented, as I say, I think it should be put on hold. I'm going to reflect on the implications of this on the timetable over the coming days, and I will look to issue a note of the meeting which sets out the next steps within 7 days. I do sympathise with those parties, as I've said, that want to see the proposal determined one way or another, and I totally understand the frustration that this is going to cause. Within my note, I'm going to request an updated position statement from the applicant in advance of the next rescheduled pre-examination meeting. And given that the applicant says that there isn't now a need for additional environmental information, I don't consider that information that was mentioned regarding the Eagles is a priority at this time. And I'm satisfied that that can be delivered as further written submissions through the inquiry process. I am going to make every effort to move through the inquiry as efficiently and fairly as possible when it resumes. And I do, again, want to thank everyone for the time today and the patience with me. And I will hope to resume proceedings soon. I do want to thank everyone for the time today. Before I close things, I noticed that there's some hands, and obviously this is going to be a disappointment to people, but this is the decision I'm taking on this. So I appreciate that that can be not what you want to hear. But I will look, I think, from seeing the timetable before me, I'll be looking to reschedule towards the end of March for our meeting, and just to make sure that all of those steps are taken. Now at that point, we'll look at the timetable. I do fully anticipate that it would be my report will be submitted to the ministers, even with this delay, by the end of next year. That is the timetable that I'm looking at the moment. This will be confirmed once I've verified that through the meeting note to make sure that that is achievable. But that's the reassurance I'd like to offer at this stage. I don't think that there'll be, I wouldn't like to say significant. I'd say extensive. I don't think there'll be an extensive delay beyond what I was aiming for anyway, providing that we can take things forward. And as I say, this abeyance until the next PM doesn't mean at that point we're going through this negotiation period again. At that stage, we'll be progressing with things. Mr. Dawson, before I close the meeting, you have your hand up.
Oh, yes, sir. Just on the point that you, in regarding the environmental survey, and sort of airbrushed over that the environmental impact is one of my primary concerns with this development. Not only the community impact aside, we sort of just brushed over the fact that the South of Scotland Eagle project, there was a fatality not too far from this development with a wind farm in November of 2024. Moving on from that and that aside, the blue hare population within this development area, the mountain hare that's more commonly known as, has that been fully assessed?
At the moment, we're not going to be talking on the specifics. There is, if you read through the agenda there, I've been as inclusive as possible in issue number 4, which is ecology and ornithology. And what I've said in there is the response to issues raised regarding habitat lot for protected species and bird activity. So that was to give cognizance of any protected species, and there would need to be a habitat management plan as well. Again, I don't want to talk about the merits of the proposal in today's meeting. That's not what this is for. But yeah, there would be consideration given to that. I didn't mean for it to appear as though I was brushing over in any way the environmental impact here. What I'm saying is that the applicant requested to submit additional environmental information, which addressed certain matters, as you'll have seen in the position statement, which it was contended by the applicant needed to be consulted upon as additional information. Now, the applicants confirmed earlier in today's meeting that that isn't necessarily the case now. So it would relate, there is still a matters concerning eagle populations, and that would be subject to further written submissions and agreement of appropriate conditions, and also any management plan, be it a regional eagle management plan, compliance with that. I wouldn't like to prejudge at this time.
Yeah. Thank you, sir. It wasn't so much the eagle population in its individualism. It was the blue hare population that I have significant concern regard, and the absence of any mention of the blue hare population in any reports.
Okay. Well, what we'll do is, it's good that you've opted into the process, because you can raise those matters during the further written submissions stage when we come to take evidence on that, and the applicant will respond to any matters that you raise through that, as they will all further written submissions. So rest assured that anything that you bring up will be addressed and by the applicant. They'll respond, and then I'll determine whether or not that's to my satisfaction, and I'm writing my report.
Very good, thank you.
Thank you. Mr. Kerr.
Yeah, thank you, sir. Just looking at item 4 on the agenda, which relates to cumulative landscape and visual impact assessment with revised visualizations, taking into account any wind farms in the planning process since the submission of Teviot wind farm. Now, you're obviously pushing the timetable back a bit. At what point does the visuals, because we've obviously had a stop at NISO while over the, coming up to Christmas, New Year, and then the timetable is going to be opened again to NISO, the energy consents, having stopped the process, are now going to let applications come on. We know that there potentially are more due to come in. At what point do you envisage taking a cut-off date?
Yeah, so what I would anticipate would be that at the next pre-examination meeting, a request will be made at that time for the cumulative landscape visual impact assessment. Now, I have a tree of notes here about which way certain things went in my mind. So if there isn't additional environmental information, that would be requested by myself at the same time as the further written submissions, which would normally be about 8 weeks after the date of the meeting. So it'll be the date of the pre-examination meeting. Anything in the planning process at that time, I would expect to be included in the updated cumulative landscape visual impact assessment. Does that answer your question?
And for clarity, does that include scoping or just it does include scoping? That's very clear. Thank you very much indeed, sir. Very clear.
Dr. Ford.
Thank you, sir. We respect your decision, sir. You obviously appreciate that we disagree with due respect, but we do respect your decision. I also understand it's a very complex situation, so sympathies for you in that situation. I have a simple question, sir, which is when you're issuing your minute from this or note from this meeting, will you please give an indication of the time when you expect the oral hearings to be taking place? Following on from the March deadline, it's very useful in terms of scheduling workload, etc., etc. Thank you.
I will do. Thank you. Mr. Trinick, is there anything that you'd like to say on behalf of the applicant at this point, given what I've just said?
No, sir. Thank you very much indeed.
Okay. So thank you very much again. I think at this stage, rather than go through the remaining agenda, it'd be premature to do that until the rescheduled meeting. I apologise. I do thank you for the time you've put in today, and I will, in my note of the meeting, make it clear that disappointment has been expressed by members of the community to the delays. So there will be the record of that. Thank you very much for your time today. I'm now going to close the meeting. Thank you.